Thank you for joining. Thank you for becoming a member. Anyone coming live can ask your questions. I'll be live for about 40 minutes or so. About 40 minutes. Okay, I'll take the questions on the channel. Squishan, thank you for becoming a member. If you have any questions, you can ask me. Okay, I have a question from Himal. Hi sir, I have failed my dissertation in masters. Can I switch to work permit? Yeah, if you are on a student visa, you failed your masters, you can still switch to the skilled worker visa. There is no restriction. So last year when the changes were launched, it wasn't clear, but now from our experience of applications, it is clear that even if you have unsuccessfully completed the course, you should have completed the course of study. That is important. Attended the university, given all the examinations, dissertations, whatever submissions, and even if you have failed. So in your case, Himala, you have failed your dissertation. Can I switch to work permit? Yeah, you can switch to a skilled worker visa even if you have failed. Next question I have is about sorry. Yeah, the next question from Kenza is I think her skilled worker visa has been cancelled by her employer. So, okay, so the employer has cancelled the skilled worker visa. She's paid the 3 years of whatever fees and all for herself and the dependents, and currently have 1 year and 6 months remaining. Cancelling a skilled worker visa is connected to your job. If you are being made redundant from your job, you are being fired from your job, then the skilled worker visa cannot be maintained by the employer. They have to cancel that visa. They have to do a reporting through the SMS. Uh, your question is if there is any way to contest the cancellation. I don't think there is any way to contest the cancellation. If there is any employment or law rights, you should speak to an employment lawyer for that. Uh, if it was unfair dismissal or whatever that was, that is out of immigration matters. So, but you cannot contest any cancellation of a skilled worker visa because it's a sponsored visa and the employer has given you till the time the job is there, the visa is there. If the job is not there, the visa is not there. That's the logic of Home Office. Next question. Can I skilled? So the question is about can I still work more than 20 hours for another employer as a nurse on a healthcare visa? Yes, you can. So more than 20 hours. So the question is, can I still work more than 20 hours? More than 20 hours. Up to 20 hours, not more than 20 hours. For another employer as a nurse on a healthcare visa. Uh, no, you cannot work for more than 20 hours. I think as of today, there was previously, I think the question is on my video where there was a concession. It was a year back or something where healthcare workers were allowed any number of hours to work with any employer because there was a shortage in the NHS and all. But I think that concession was for a temporary period, sometime September or so. It ended, I think so. So no, you cannot work for any number of hours with another employer. You even if you are in a healthcare occupation, you are restricted to the 20 hours of supplementary employment in any skilled occupation with any employer. So you can only work up to 20 hours additional. Okay, Nabil, thank you for your question. Live question, international skilled worker visa processing time, sir. Processing times are still standard from the Home Office, whatever last week's updates I have. Usually, standard processing time is about 15 working days. It comes to about 3 weeks, and priority is 5 working days. Okay, so that is skilled worker outside UK. Vijay Reddy. My husband has been overstaying. I am planning to go to the skilled worker visa. Does my husband overstay affect my application? Yeah, Vijay Reddy, you asked this question, I think, in last live also. So I think my answer remains the same. It would ideally affect your application. You should speak to immigration lawyers and get proper advice. Because the first doubt that the caseworker will have is why is if your husband is overstaying and then you are coming over, the whole family is going to come here. So maybe everyone is going to abuse the immigration rules. So that is the doubt that they will have. But if you have a genuine cause, genuine employment on your side, they are going to assess your employment situation very, very carefully. Remember that. And so they may interview you or anything like that. because your husband has already overstayed in the UK and you are coming on your own skilled worker visa to live in the UK. So definitely speak to legal representatives, take proper advice. There is a chance that it may be refused because they may not believe that there is genuine employment. But if everything is genuine, how you find the job, etc., etc., you, you speak to an immigration lawyer, take proper advice on this. There is a chance, it may be a 50-50 chance from what you have told me. I don't know all the facts of the case, but if your employment is genuine, then only then you should consider applying. If it is not genuine, you're just trying to buy a certificate or something, don't do it. It will be 100% refused, I'm pretty sure. So being in case of PSW post study, after a couple has paid their post study, can one write to home office to pay his children and their post study fee later? Are you talking of immigration health surcharge or visa fees? Clarify that, or both, whatever that is. So, Bubakar, good afternoon. Waiting overstayer parent in the UK processing time. Thank you. Processing time, I told you last week also, Bubakar, I remember. It's 12 months and going. So, there is no standard processing time for such applications. Overstayers parent visa application, there is no standard processing time. But currently, it is 12 months and going. So, you may have to wait for that period. Okay. Okay. Immigration health surcharge. So, you asked, Benga, in case of post study, after couple has paid their post study, can one write to home office to pay his children their post study fee later? Write to home office. What do you mean? You have to fill up the application form, submit. When you submit the application, at that point only you pay the IHS. So I'm not sure what you're going to write separately. And you cannot submit the kids' applications before paying the IHS. So I'm not sure. If there is a shortfall and all, Home Office will always write back to you. That is not a problem. They will write back. So there was currently a system issue going on where IHS was not calculated for graduate applications properly, and it was only charging 6 months IHS, I think so. But then in such cases, you can pay lesser IHS, and then Home Office department will contact you to pay the difference. But I'm not sure what you're talking of. You can pay later the IHS and all. You pay the IHS when the applications are submitted. That's how it works. So this one. Okay, live. Can my husband regularize his stay? If he has overstayed in the UK, it is not possible to regularize his stay. He has to go outside the UK and file from outside UK. And I'm not sure how long he has overstayed. The overstay bans will come in. If he has overstayed for more than 3 months or so, yeah, he may be banned for at least 12 months from the UK. Sudhari, for ILR, does Home Office check that days absent from the UK matches with approved leave days? From the employer. No, that is completely irrelevant. Don't worry about it. Um, Home Office never matches. I know that they don't even care about it. So I think when you are answering on the ILR application, you have to give the correct facts, whatever period of time you were outside the UK. So one more addition over here. The requirement on the form, you will still see that you need that absence confirmation letter from the employer. That letter is no longer required. It has been taken out from the immigration rules about more than 2 years ago now. We have filed many applications without that absence confirmation letter where the employer used to confirm that we confirm the following absences, following holiday periods, annual leaves, or whatever of this particular employee. That is no longer required. We've done many applications without those letters now. The requirement has been taken out from the rules, but that document, absence letter, will still come up on your checklist. Yeah, so if you are still submitting, I know Home Office caseworkers are going to ignore that because rules don't require it. So summarily, to answer your question, yeah, they are not going to match your approved leaves and outside UK dates. Next question I have on the channel. The question is from Shivendra Singh. If UK spouse visa application refused due to overstay 39E, okay, 39E within UK, is it any chance to get visa from applying after just 1 month? Yeah, if you don't, your UK spouse visa, no overstay bans, that is fine. Yes, you can apply. Is it any chance to get visa from applying from India, which is outside UK, just after 1 month? Yeah, if an application is refused inside the UK, why would it be overstayed? Yeah, because you filed inside UK. Yeah, the question is about Shivendra filed inside UK application and he had overstayed in the UK. That's why I think they refused the application. His question is, if he goes back to his home country and applies from there within a month, will it be considered? So it should be fine. If that overstay should not affect for spouse visa. Any overstays are ignored for spouse visa because that is on human rights grounds. The ban periods don't apply. So yes, you can apply within 1 month, after 1 month, or even immediately when you enter your home country. Vijay Reddy got immigration in October and my child born in UK. She don't have personal passport to come back to India. In this case, can they regular stay? Yeah, not having passport is not a reason. They can apply to the Indian embassy and they can give a one-time exit passport. It's not a big deal. So not having a passport is not a reason. So I know it may not help. The child is born in the UK, but still they will have to somehow work with the Indian embassy and get the passports if possible, or contact the home office, what is that, returns, voluntary return service, and try to see if they can help out with getting that one return, what they call it, a passport given just for one exit to India, back to India. But they will have to leave the UK. You will not be able to regularize their stay inside the UK. So next question on the channel. Okay, my BRP not coming 21 days ago on report, but still no solution. Should I do my BRP now? My skilled worker visa. Okay. So the question is from Sam Droke 1 day ago. So today is 22nd December, 1st December. So the first thing, update for everyone, BRP production has been stopped. No one will receive any new BRPs. No one in the world. Okay. So I think Sam, you are asking your BRP not coming. You will not get a BRP. The BRP production has been stopped. I think end of October, 31st October or so, this production was stopped. So don't wait for the BRP. You have to apply for the e-visa. The instructions should be in your approval email. I've done report. Yeah, you don't get into reporting BRP not received and all. Nobody is going to receive BRPs now, so that's useless to do that. What should I do? You have to apply for the e-visa. The instructions should be on your skilled worker visa approval email. How to apply for the e-visa. Okay. If someone's on a post-study work visa for about 6 months and gets a sponsorship job, PSW sponsorship job, that's not in healthcare, can they get back the immigration search and they paid for the PSW? Okay. Yeah, the question is Sarma. Yeah, Raja. Yeah, so your question is, so you got the post-study work visa, graduate route visa for 2 years. Within after using 6 months of it, he's switching to skilled worker visa. Question is, will he get back the remaining 1.5 year of that skilled immigration health surcharge? Yes, proportionately 6 months blocks. Minimum 6 months leave should be remaining on that previous visa. A refund will be issued with 6 months blocks calculations. So if you have a total of 1.5 years, 6 months into 3, yeah, then they will refund for 1.5 years of your immigration health surcharge that you paid for graduate route when you switch to your skilled worker visa and pay the new IHS. So the rule for immigration health surcharge refund is whenever you pay a new IHS, only then the old IHS is refunded for the remaining period, and minimum 6 months remaining period should be there. Okay, next question. So guide, please, if a person, where is that? If a person on skilled worker visa and his annual salary is 3,700, now we want to do additional 20 hours work. What are requirements for 20 hours, like per hour minimum wage? Yes, for the 20 hours work, so the question is about skilled worker 20 hours supplementary employment. So he's asking, Mahmood is asking, what is the salary requirement or whatever payment requirement for the 20 hours, like minimum wage, etc. That 20 hours supplementary work you can only do in a skilled occupation. So Google search for list of skilled occupations. There is that skilled occupations list. You can only work. What is the meaning of skilled occupations? Those jobs are on the list of occupations which can be sponsored for a skilled worker visa. Though for that 20-hour supplementary employment, you don't need sponsorship, but you can only work in skilled occupations. You cannot go and work in any retail, Primark, Asda, anywhere or anywhere as a retail salesperson. You cannot do that. So those jobs are not allowed. People always ask me, you cannot do delivery, driving, or anything like that. Yeah, so those jobs are not on skilled occupations. So the minimum wage is the minimum as per the law. Yes, at least minimum wage should be paid for that job, uh, but you can only do a skilled occupation. There is no minimum salary requirement for that 20 hours. Whatever is the minimum wage rate for that particular job you are doing, that should apply for the 20-hour supplementary employment. I'm writing question instance. I need the UK student visa. The visa dependent of EU member. Okay, the question is about EU settlement scheme, I think. So you came to the UK on a student visa, immediately applied for as a family member of your EU uncle. Yeah, this is a common mistake that people do, that EU family member visa is not an easy one. Everyone just tries to apply left, right, center, and Home Office refuses it left, right, center. I know that. So your uncle may be living here and he may be an EU member, EU national, and you just applied because your uncle was an EU national. There was a requirement of dependency and all of that, or living in the same household. I'm pretty sure you didn't meet that because you just came to the UK for the first time on the UK student visa. So you did whatever appeals and all, everything is being refused, and that is being refused correctly, because if you don't have meet those requirements, you cannot get just as an EU national. Just because your family member, an uncle, is living in the UK, you cannot get some status under the EU settlement scheme. There are several other requirements, dependency, living in the same household, etc., etc. So reappeared. So you reapplied and appealed. No, there is no more further steps. So you are asking me any further steps I can take, desperately trying to get myself sorted. You will not get anything on that EU settlement scheme. Don't waste your time doing that. I don't know whoever is advising you. You are not going to get it. You already tried, I think, 2 or 3 applications, appealed it, then again reapplied and appealed. Whatever you've done, nothing doing. You cannot get anything on that. My status is settled. Is that so? The next question from Car to Cho. My status says settled. Is that mean I'm under the EU scheme? Settled. Settled status. Yeah. No. Because sometimes I think these e-visas are also showing settled. Yeah, it doesn't matter. I think it's a very difficult one. I know Home Office always uses different terminology. They have stopped writing that indefinite leave to remain also on those e-visas also. So yeah, just by looking at that settled, yeah, it is difficult to interpret it as you are under the EU settlement scheme. I don't think so. Yeah, because they write settlement, settled, indefinite leave to remain, whatever that is. Next question on the channel, I have passport, can't scan. They said unable to take the image. What to do? Yeah, for that e-visas, I know many people are having these issues, unable to scan BRP, scan passport. There is that web chat from Home Office. That is the only way to get it. I know even lawyers will also go through that only. So if you are having issues scanning those passports and all, contact that web chat. That is a support for the e-visas. Yeah, Google search for it, and I think it's a chat. It is 24 hours available or something, and they are the only people that can help you. Or call Home Office if you are unable to scan the passport or anything like that. Next question, I have live Pama. Hello, please, I made a mistake in my skilled worker visa from student visa. Okay, can I get a refund? Mistake in the skilled worker visa. Already paid. I have already paid, but I have not click on confirm and submit. Okay, you have not done the uploads. That's the last step. How will I reapply and get my refund? Reapply and get my refund. Yeah, remember, if you try to withdraw that application, first very important point, you may become out of time. So you may not have any permission basically as soon as you withdraw that application. So be careful on that. The only way, if you file the application and your current permission has expired, I'm assuming, do you still have your student visa? Do you still have your valid student visa? If you answer that, then I can answer it more clearly. If your student visa is still valid, that is my first question. then I can answer it. So yes, your student visa is valid, so you can cancel that application. So if you don't upload, it should tell you over there only. If you withdraw that application at that point, the refunds and all will take time. Remember that if you paid any fees, Home Office doesn't refund so quickly. It may take up to 28 days or even more. So if you should have enough money to make the second application, you may be able to cancel that one. But what is the mistake on your skilled worker visa? If you tell me that, I'll tell you if you need to withdraw it or it is okay. Whatever that is, whatever that mistake is, if you briefly describe it, I try to answer. Avoid withdrawing, but then yeah, I don't know what the mistake is. If you just tell me what that mistake is. Next question, passport scan is done. Please, does it mean if I spend 180 days outside the UK in a rolling 12 months, 180 days under skilled worker visa, can I spend another 180 days in another rolling 12 months outside the UK? Yeah, so the question is on 180 days outside the UK in any 12-month period for skilled worker ILR. So that is the requirement if you are applying for a skilled worker ILR in the last 5 years when you have been on that skilled worker visa in any rolling 12-month period, you should not have been outside the UK for more than 180 days. So the question is if you do it in first rolling period, can I use 180 days in the next rolling period? Yes, you can. But remember, the maximum allowed is 180. If it becomes 181, you have broken the residence requirement. You will have to start your qualifying period again. So 180 is the limit. Yes, you can. What you asked is correct. Once you have one rolling period of 12 months, you use up to 180 in the next, but it is a rolling period, so it keeps on moving. Remember that it's a cumulative number. But yes, we can accrue 180 days in any 12 months, every 12-month cycles. That is correct. I haven't heard from IPAMA. So if you, I'll anyways briefly answer. So if you withdraw the application, the application should give you the option over there only where you have submitted. After that, there should be an option to withdraw or cancel the application, and then the refunds would be processed. But I know Home Office doesn't do it very straight away. Those refunds you may have to follow up with them. They are not good with refunding those withdrawal application fees and all of that. So next question, Pooja. Your videos are really very helpful. Thank you, Pooja. I need your assistance for the bill. It's regarding skilled worker dependent. While filing, it's asking me when applying has expiry date. When applying has not received a decision yet. Okay. So the question is, what should you put as the work end date of the main applicant? So Pooja's question is, I think her partner has already applied for the skilled worker visa. It is in processing. She is subsequently submitting a dependent application. What should she put as the visa expiry date? Because the husband's visa is not yet decided only, so there is no visa expiry date. You put the work end date as per the cost. That should be fine. That's what we also do, and accordingly, whatever the IHS is calculated, that is what you should pay. So put the work end date for the visa expiry of your husband when you are filling up that IHS part of the application. Okay, so IPAMA, this is the mistake. I mistakenly filled. So you filled your skilled worker application work date on the 4th of November instead of 1st of December. 1st of December. Okay. And second mistake is filling. Fine. I have been in the UK for 2 years and 10 months instead of 2 years and 1 month. 2 years and 10 months should be fine, but about the work start date, what are they going to follow? Yeah, if since you've done it, yeah, I wouldn't ask you to take any risks. If it was done by us, I would have just put a covering letter and covered these points. I don't know how they deal with individuals' applications, but such mistakes can be covered. Uh, if legal rep has done it, they can be explained. But then, yeah, if you want to withdraw the application, because I think work start date and all, they would usually override and they would go as per the cost anyways. But the work start date is used to calculate the IHS and all of that. I don't think these things are going to affect the decision on the application. But anyways, to be perfect, yes, you can withdraw the application and refile it. Uh, yeah, in my opinion, I don't think these mistakes are going to affect. These can be explained in the covering letter, but don't quote me on it. If we were doing the application, I would have covered it in a covering letter. But then, yeah, I don't advise individuals dealing with home office for such mistakes. So yes, you can withdraw and refile the application. Okay. Akshay, my Naric certificate year of award date is mismatch. What can I do? Year of award mismatch on the Naric certificate. Naric means UK Actis, which is called Actis now. In the olden days, it is called Naric, UKNARIC. That is the English language equivalency where outside UK degrees are, they were evaluated and they confirm the level of English. The year of award date is mismatch. You have to get it rectified with UK Naric or UK Actis. I think Actis may have issued it ECCTIS. Write to them, check with them why they have done the mistake, because they should copy exactly what is on your award. So if there is a mismatch, I don't think home office is going to accept that, because they will look at the award also. So if the award has whatever 2001 and Actis letter or Naric letter says 2002, obviously there is a mismatch. So something is wrong. They are not looking at the right award or whatever that is. You need to get that Naric certificate rectified. That is my answer. Hey sir, my employer gave me manager role, but I'm on senior care assistant visa. Can I work as a manager? I need to change. Employer gave you the role. Yeah, basically, so the question is, I think it is about a care home. Yeah, it's a care home question, I think, care work related. Hi sir, Gaurav is asking, if my employer give me manager role, but I'm on a senior care assistant visa, can I work as manager or do I need to change? I don't think you are responsible for doing any changes. It is the employer's responsibility to allocate you to correct job code and assign you the correct course. It doesn't fall on you. Whatever the employer is saying, you have to do the work. I understand that, but I don't think you should be worried about it. It is, if there is any breach, it is the employer's compliances breach. It doesn't affect your skilled worker position or your ILR in any ways. If they have given you senior care worker and you're working as a manager, that is more for the employer to do the corrections. I don't think you would need a new visa or something, but then the employer has to decide if the job role, they have to match the job role and see if your SOC code is changing. If the code is changing, then a new visa application is required. If the job code is not changing, new visa application is not required. Also, I don't want to include my dependent. What should I fill? What should I fill? Sorry, I cannot answer application questions over here. I can only give you brief advice, but for that you have to book a paid consultation with us. Then we can advise you on specific items. What should I fill on the application, etc. So next question I have. This one is done. IGS is expensive of having five. Okay. Someone has made a comment. IHS is too expensive for 5 years with 3-4 family members. Yes, I understand. Total cost for PR, skilled worker visa. Okay, example each person. You've done the calculations. Yes, I agree. IHS fees is expensive. I understand. Okay. Next question I have. I'm looking for PhD student visa with dependent. I completed my master's in 2011. PhD student visa and have 8+ years of experience in research development. Yeah, sorry, I cannot give you a student visa. I don't have the authority. The way you have to, if you want a PhD student visa, you need to apply to the universities, get the offer, accept the offer, and also to ask for a CAS for them, and then apply for the PhD student visa. That's how it works. So you need to approach the universities for the student visa. That is the first point. First, you should get an offer on the course for the PhD, then get a CAS, and then apply. Okay, next question. Hi, will you please be able to advise if the below is okay legally? Job code, Yeah, you are asking me to calculate the salaries for a particular job code. I cannot do this during a live. You have to book a paid consultation. It is a risky advice and it's covered by our indemnity insurance and all. So I cannot calculate salaries during lives. That is in a proper in-person in video consultation or an audio consultation that we offer, during which you have to do that. We can calculate the numbers for you. Cannot do that salary calculations during a live. Yeah, the next question is it okay to count 1588 per hour including service charge for chefs? Service charge for chefs. You can, so the way I would put it, any types of income that you receive. So service, I think chefs receive service charge. So the question is, can you add that service charge towards and account it towards the 1588 per hour? Only if it is a permanent component, it is shown on your payslip and you get it every time. So throughout the year you will be getting, and it is a fixed component. So that's how home office looks at it. Doesn't matter what you call it. But what I understand from the self service charge, I don't think you would get it throughout the year. And for the fixed part, fixed amount also, I don't think you can include that service charge aspect, which is I think topped up. You may not get a service charge, I'm not sure. So I don't think you can account the service charge towards that 15.88 per hour. Hi sir, how to show e-visa when back travel to UK from India? To UK from India, India airport, please let me know. So the way outside the UK, so the question is about e-visa. So everyone is having e-visas now, and from 1st of January, yeah, so what is going to happen? So Jay saying you are going to travel from India to the UK. When you go to the airport, when you go to your carrier's desk, they put your passport details on the system and they are going to see what status you have. For example, you have a skilled worker visa permission valid up to next year 31st January 2025. They will see that you have permission to remain in the UK till 31st January, and that's how they are going to allow you to board the flight. If they don't see that, they are not going to allow anyone, the person, to board the flight. So that's how e-visas will be checked. That's your question. In airport, let me know in India how to show a visa. You don't have to show it. That's why always update your identity document. You should have your latest passport updated on your e-visas, definitely. And if you have those expired BRP cards, definitely carry them also with you. Also, just updating everyone, keep those expired BRP cards with you, because that holds your biometrics data, fingerprints and photograph. It will be helpful with future applications. That is what Home Office has told us. Please keep holding that expired BRP cards. Yeah, that's the part, and that's how e-visas are checked. They will be checked at the counter when you go to the carrier's desk. When you check in, I think that's the point, or some point before you board the flight, the carrier is going to check that you have e-visa. They check it, they will check it on their system. You don't need to carry any printouts and all. They are not going to look at printouts. They are going to see it through the live system of the UK government. What document should I submit when reapplying? So whatever documents were required are required for your visa application. That's what you should submit. So it doesn't change anything. So when you are trying to withdraw an application and make a new application, it's as good as you are making a new application. So whatever you were planning to submit for your first application, which you're going to withdraw, you should submit the similar set of documents. Okay. Next question I have, sir. I got NHS cost letter. Now pre-employment checks going on. Okay. And also conditional offer letter received. Still I'm not giving resignation present employer because pre-employment checks. My question is, shall I apply online visa with costs and conditional offer letter? Costs and conditional offer letter. Okay, the question is, so I think NG Yadav, you've got a job with NHS. NHS is doing the pre-employment checks. They have given a conditional offer. I don't know conditional upon what, whatever that is, conditional upon the pre-employment checks, I think. And you've got a cost. So your question is, can I apply with the cost and conditional offer? I think that conditional offer is completely irrelevant for Home Office. That cost itself is the main document for Home Office. So if you have the cost certificate of sponsorship, then you can fill up the skilled worker application and submit it. So that is my answer. Next question I have. I've traveled to the UK in October 10 on student visa. Unfortunately, my college was blacklisted in February. I returned to India on my own with a 5-year Indian passport issue. Blah 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 blah. During my stay, I did not file any appeals. Obviously. Yeah, so this is the question from Sunil Kumar. So he has overstayed in the UK. He has given a lot of history, whatever has happened. So you did not file any appeals. You did not file for such as asylum or crimes or bankruptcy. You done not done anything wrong. Didn't file any frivolous applications, immigration applications. So if you overstayed for more than 3 months, then your ban period is minimum 12 months. So minimum 12 months ban for any overstays, and you left at with your own expenses. So the government did not pay for your flight. So if you left at your own expense more than 3 months, it's a 1-year ban. Skilled worker visa requirements. Interesting. Yeah, the best way to look at the skilled worker visa requirements is just Google search for UKVI skilled worker, and that page gives you all the requirements. But the main requirements, I'll just help you out, is you need a certificate of sponsorship. That's the first one. English language pass at level B1 in all 4 components. What else? And maybe finance also. I think 1270 is the maintenance that you hold at least for 28 days. Finance, English language, costs. Those are the three main, and rest is application and all. So those are the requirements for skilled worker visa. Abdul Rahman, live question. I'm on pre-settlement status and have applied for settlement status, but I'm waiting for the outcome. Recently convicted by the magistrates, sentenced to 140 hours of community service. Yes, you should update the home office with what has happened. So whatever letter or something has been sent to you, send it to that. You can upload it in your application also if you have that login, and you need to update it or send it to the resolution center. There is an EUSS resolution center. So yeah, it's always good practice to update them with what is happening. They will anyway see this, I think, most probably, but on the application you may not have stated. But if it is after the application is filed, it is better to update them. But on a settled status application, 140 hours community service, I'm not sure. It's out of court disposal, so I don't think it may affect much. Yeah, but whatever has happened, you have to report it. It is good practice to report it to home office. That's what my advice is. But if you tried, but you should try your best. Try to do it to the USS Resolution Center. Maybe call them, speak to them, tell them this has happened. They will tell you how to update it. That's the best way to go. Who pays the IHS fees, the applicant or the employer? IHS fees. So the question is, who pays the IHS fees? IHS fees can be paid by anyone, the applicant, employer, or anyone. That doesn't matter. Home office doesn't care. Uh, it depends on the employer's policy. Sometimes employers cover everything, including the IHS. Sometimes employers cover part of the fees. Some of the employers, we represent several employers with sponsor licenses. Some of the employers that we see, they cover everything, all the parts of the application. Some of them ask the applicant to pay the visa fees and the IHS. Some of them ask the applicant to pay the IHS fees. So it depends on the employer's policy. That's what I would say. But home office doesn't care who pays the immigration health surcharge. Anyone can pay it. Okay, there is an F on which one? What happens to the dependent? Okay, next question, Emmanuel. What happens to the dependent if a care skilled worker visa holder reports to the home office about relationship breakdown? If a care skilled worker visa holder. Yeah, so it doesn't matter, care or any skilled worker visa. If you report, will this affect my application? I don't think that 140 hours. So Abdul's question on one, he got 140 hours of community service and he has pending settled status application. Out of court disposal, small things. Does it affect? Does it me? I don't think under the EU settlement scheme it should affect your application, but that is just, yeah, prefer to speak to an immigration lawyer and get do a proper advice session where rules have to be matched, what the suitability requirements, etc., and what has happened in your case. Yeah, for proper answer. But summarily, from 140 hours, I don't think, but don't quote me on it. I'm not looking at the rules and suitability requirements in front of me, but it's an out of court disposal. I don't think it should affect. But for confirmation, book a paid consultation with us or speak to any lawyer and get advice from them. But my first instinct is I don't think it should affect. Yeah. So, yeah, if a dependent, so care worker holder and a dependent, if the care worker holder reports relationship breakdown to the home office, the dependent's permission will be cancelled by home office. So remember that they will get the 60 days. There is a reporting form, relationship breakdown, reporting relationship breakdown to home office. The main applicant will report it through that form. It will be picked up by the status review team. I think so. I have made another appointment, another video on that, on detailed relationship breakdown things. So yeah, it will be, the status will be reviewed and they will issue the cancellation email to the dependent, because their relationship is no longer subsisting. Main applicant has reported relationship breakdown, so the dependent no more qualifies, is no more eligible for that permission what they have. So this should be Johari. Okay, that was so informative. Thank you. Can you confirm where to find such jobs, as I couldn't see any filter to limit hours or mention that I am seeking supplementary work on job portals like Indeed. Sorry, I cannot advise on how to find these 20-hour supplementary employments. Uh, I don't know, you have to go to all these job portals or speak to all these employment agents or whatever they are, consultants. So the question is where to find these 20 hours jobs, skilled jobs. I'm not the right person to advise on that. Sorry about it. But then online sources are the only one. I think that's the only way you can look for these 20 hours of skilled occupations for supplementary employment. You can try and find in your own field of work. If you are doing 40 hours with the main employer, for example, try to find in that job. That may be the best suited one or the easiest one to get, I think. But yeah, that is just my suggestion. Okay, Sheikh Irfan, live question. Once I speak already 2 years, 6 months on healthcare visa, I spent, okay. If I change my employer, okay, then 5 years time duration will start again. You'd like to change my visa category. No, it will not restart. So the question from Irfan, I think what everyone can see is, so you already spent 2 years and 6 months on healthcare skilled worker visa. So skilled worker visa for my purposes. Okay, if I change, you change employer, whether you do it in the same job code or you take another job code, whatever that job code is. So you should be fine. It doesn't reset. Your you have already spent 2.5 years, so you spend further 2.5 years with that employer. It does not reset. So that is it. Next question. How much time take time to get administrative review result? My 9 month gone. Administrative reviews are at least 12 months and more. I know of some cases from other lawyers, they are waiting for 2 years for admin reviews. That's why we always advise against admin reviews. Yeah, it depends on the case. Sometimes if a reapplication is possible, a reapplication should be done. If there is an appeal right, appeal should be filed, or maybe sometimes doing a pre-action letter for a JR also helps. But then yeah, admin review is the last resort we go for. Yeah, but yeah, admin reviews 12 months and counting. 12 months, 16 months, whatever, 18 months, 2 years, but at least 12 months that I know of. So I think Selena, you are waiting for 9 months for your admin review. That is normal for admin review. They are going 12 months and over. OP is the employer. That's done. Okay, the question from C Raj is, hi sir, I got my cost draft last cost draft, but still I'm awaiting my costs. Sorry, I don't understand the question. I got my cost draft last, but still I'm awaiting my costs. Hmm. Maybe I'll try to think, try to put words and try to interpret it. If you can come live and ask, but then yeah, if you got an allocation, then that cost can be assigned. That's one way I can answer it. Cost draft, but still I am waiting my costs. Hmm. Sorry, I really don't understand that question. What is a cost draft? So the way the cost works is, once you get the allocation, it needs to be assigned. Yeah, maybe come live or ask it in a different way. What my cost drivers? Okay. So yeah, Sheikh Irfan, you are asking, I want to change my visa category. If you change from skilled worker visa to any other visa, you will lose the 2.5 years. You will reset it. For example, you become a spouse of a British citizen, you get a spouse visa. You will have to complete new 5 years. So it will reset the count. You will lose that 2.5 years with your skilled worker, care worker visa, whatever that is. So if you change the visa category, if you're on the same skilled worker category, it helps. You can count it forward. If not, you lose it. You start a new count of 5 years. I can't get it. The term discount means low threshold. What this means? Discount for employees. Okay, visa salary guide calculation easy. Okay. Discount means lower salary. Yeah. So the question is about the on my video for skilled worker salary guide where all the salary calculations I've explained. You're asking the term, I can't get it, the term discount means lower salary. Yes, it means lower salary. So the employer can pay lesser salary if you are in one of those categories. For example, you are a student switching, so you are fresh, you are on the new entrant category, you are a new entry in the UK, new entry on that job category. So they can pay, you are less experienced or zero experience, they can pay a lesser salary. That is what is the meaning of discounts. So the discount basically helps the employer to pay a lesser salary. That's how I would explain discounts. So the question is, Roy Sandy, I not got any email, so what can I do? Apply for e-visa to replace. Yeah, so everyone who has BRP has to apply for any visa. If you have not got any email, just don't worry about it. You have to apply. Google search for apply for e-visa and then gov.uk page comes up where you create the UKVI account and then the e-visa. So don't wait for those emails. Those emails, Home Office has completely stopped them also. They come randomly or not, we just don't care about it. So Roy is asking, so he did not get any email to create an e-visa or UKVI account. So don't wait for that. Just Google search for the government website, create a e-visa, UKVI. You should get the website and create your e-visa. Don't wait till the last moment. Okay. Bobakar, okay, you came live and you asked videos on particular topics. Okay. So, Fayaz, live question. I'm following for 2 years. Thanks for the wonderful info. Thank you very much, Fayaz. Yeah, all your comments keep me going, help me create more videos, and yeah, thank you very much. Thank you very much. Okay. Next question, Ravi Shankar. Hi. When we update the skilled worker visa after the first 3 years? Okay. Next question, when we update skilled worker visa after the first 3 years, which cost is needed, ISC liable or non-ISC liable? Also, is there any cost for the employer to issue the new cost to extend the visa for another 3 years? Yes, there are two parts to the question. First is ISC liable or non-ISC liable. Most of the jobs are ISC liable. So if for the first time the employer may have selected, there are many reasons for ISC liable, but I'm just taking an example. So Ravi Shankar's question is, you got a 3-year visa and now when you are extending for further 2 years, I think, should you select ISC liable or non-ISC liable? It depends on the job code. Usually most of the jobs are ISC liable. I've seen there are only very less jobs which are exempt from ISC. So the employer can look back if they have paid ISC for the previous application, they are definitely paying the ISC for the extension also. The ISC has to be paid because it is the same job code, I think. So what was done for the previous cost, do the same. That's my advice, provided same job code, SOC code and all is being used. Second part, is there any cost for the employer to issue new cost? Yes. If an employer is issuing a new cost, they will be paying the ISC immigration skills charge, which is 364 per year of visa. So if you are getting, for small employers who are having less than 50 employees or so, and there are other numbers also, but usual for small employers it is 364 per year of visa multiplied by 2 years for your 2 years visa. Large employers is I think 1,000 pounds per year of visa multiplied by 2, plus 239 of the cost fees. Certificate of sponsorship assignment fees at the point of assignment they pay 239. Yes. Okay, next live question, Mahmuda. I'm a student. I have a receipt on 13th of January, but my visa will expire 27th of January. Okay, my results will publish on 10th of March, 27 to 10th. So 1 month, 30 plus. Yeah, so let's say 60 minus. Yeah, is this case, can I eligible for apply for PSW? Yes, looking at the dates, I've done the calculations briefly. So it is within the 60 days, about 40 days or so. You should be able to, but yeah, I don't want to upsell my services. Do it through any lawyer, that is perfectly fine, but then do it through a legal representative. That's my advice. If you want our advice, you can book an advice session, take it from there. Or if you want to instruct us, you can also send us an email, contact our office, and they will get back to you with the information, whatever our fees and all are. So that's it. It is possible, it is doable. I've done many of these similar cases. We've done it with those deadlines that you told. So Mahmuda, it should be fine. You should be able to. There is some buying time going on, and yeah, and we have filed the application, asked the Home Office to keep the application on hold, and then subsequently provided the pass result. But make sure you should pass in your receipt. Okay, good luck with that. Okay, so Abdul Rahman, just received the naturalization certificate from the council after ceremony. Can I get a sticker on my passport instead of applying for a UK passport? No, there is no sticker that you get for a British citizenship. You have to get a British passport only. So there is no sticker that the Home Office gives that you are a British citizen. Okay, no more live questions, and I will end this live now. Thank you very much for anyone who joined, and do subscribe to my other personal channel also. I may be making some personal legal update videos. I have some ideas about, yeah. But thank you very much for joining. Yeah.